As you might imagine, in personal injury law and litigation, we deal quite a bit with doctors. Doctors' evaluations are crucial to determining the value of an injury case. Without that, you have nothing really. You have just speculation. In layperson speculation, however accurate it really may be, is not what matters in the eyes of the court and is not what will govern a good settlement. Rather, what governs a good settlement and what governs a successful result at trial is the appropriate expert testimony. The doctor, typically, should be a board-certified doctor. And by that, you can check certain references as to how a doctor or physician becomes board-certified. But assuming one has the right board-certified doctor, what about the conclusion that he or she makes? Well, I'd like to speak to the standard. What is an acceptable conclusion in the eyes of a court or in the eyes, therefore, of a settling party? That conclusion is first and foremost to a reasonable degree of medical certainty. That is the standard that we look for in an expert's opinion, in an expert's evaluation. They are opining, if you will, to a reasonable degree of medical or scientific certainty. That almost is the tagline of various questions we ask when we get to the issue of prognosis. Doctor, what is your opinion to a reasonable degree of medical certainty as to the future ability of so-and-so to function in such and such? Now, in a civil case, as I'm sure you know, the standard is not to a reasonable doubt. That's a criminal standard. Rather, in a civil case, the standard is more probable than not. But take this following hypothetical. A person is injured, and down the road, it is expected to a reasonable degree of medical certainty that they have an increased risk of developing post-traumatic arthritis. That is arthritis because there's an injury to the joint, and trauma, of course, suggests an accident. If that person has an increased risk of developing post-traumatic arthritis, can we, on behalf of that injured person, establish that when it's not necessarily more probable than not that they will develop that? I became aware more than 30 years ago that you can certainly elicit from a doctor, from the appropriate medical professional, as to whether an individual is at an increased risk of developing a condition, even if that condition is not likely to occur, is not more probable than not. The fact that they might develop arthritis down the road, and there's, say, a 40% chance, I argue should not preclude the admission of that testimony, or should not preclude a fact finder from considering that in the determination of fair damages. I'm not asking, will they develop arthritis? I'm asking, are they at an increased risk? And if their absolute risk, as scientists would put it, was 1 or 2%, that's, say, the population as a whole risk, but because they suffered an accident, that risk now is 40%, by all means, that should be introduced, and that should be included in the evaluation of the person's damages. I mention this because someone may say erroneously, but it has to be more probable than not. Not in this context. Thank you.